Today on Law Weekly, we discuss judicial reforms and the request by the President on the structure of the Special Crimes Court. A senior advocate of Nigeria, Mr. Mohammed BELGORE of Shofundeo Sakwe Gundigbe and BELGORE Chambers, believes that piecemeal reforms won't work. He also cautions against speed in the dispensation of justice. We also have highlights from the National Judicial Institute, where judges of superior courts gather biannually to evaluate performances and chart new courses. Plus, the views of another advocate of law who speaks on the Nigerian Senate's plans to introduce a bill to address selection and post-election violence. Also, our weekly recap of the top trending stories from the courtrooms. Hello and welcome to the program. I'm Millicent Walker, standing in for Shola Shuyele. November 19th, during the Independent Corrupt Practices and Other Offences Commission ICPC Summit on Diminishing Corruption in the Public Service, Nigeria's president at the event called on the National Assembly to fast-track the passage of the Special Crimes Court Bill. And just recently, he went a step further, asking the judiciary to put a structure in place for special courts. President Muhammadu Buhari, who was the keynote speaker at the 5-day conference for judges of superior courts on the first day, advocated for the restoration of public confidence, calling on judicial reforms.
It's a time of self-examination for the judiciary, as judges of superior courts and some government officials converged on the National Judicial Institute, Abuja, for a 5-day conference.
The All Nigeria Judges Conference of the Superior Courts, which is a biennial event organized by the National Judicial Institute in fulfillment of its mandate of continuing judicial education for all categories of judicial officers and their staff, has always been a stock-taking event for judges of the superior courts of record from all over the country to converge and reflect upon the activities of the judiciary with the benefit of hindsight. The conference also provides a platform for judges to strategize on the means of adopting global best practices to meet critical challenges in the dispensation of justice to all.
The keynote speaker, Nigeria's President Muhammadu Buhari, tasked the judiciary on sector reform and creating a structure for special crime courts.
I will advise that the conference should in its deliberations consider how to create an efficient structure for the proposed special crime courts, or the urgent designation of existing courts as special courts with competent and credible judicial officers in order to remove administrative bottlenecks in the judicial process. I will encourage the judiciary to undertake a critical review and assessment of their needs in terms of technology, competent administrative judicial personnel, and welfare, as well as skills required to make the Nigerian judiciary more innovative and in tune with modern judicial approaches.
The Chief Justice of Nigeria uses the platform to define a corrupt judge and the procedures to ensure the very best character for the judicial seat.
You will all agree with me that a corrupt judge is not only a disgrace to the bench and the noble profession, but also a disaster to the course of justice and the nation. The National Judicial Council, however, through rigorous screening and painstaking appointment procedures, continues to ensure that the best materials in terms of learning and character get appointed to the bench. The delay in justice delivery, as well as volume of cases in the decades of our courts, still leaves much to be desired. Urgent forms are, however, being set in place to take care of these challenges.
The objectives of the conference remain a platform for constructive engagement with hopes for sector reform to strengthen the judicial system.
Following the call for judicial reforms, what about them? A country like Peru created a 10-year plan following reports and observations that large segments of the population had very limited access to the judicial system. Corrupt practices could be found in the court system, among public prosecutors, the police force, many sectors of public administration, and also that there were legal uncertainties and inequality before the law. So what did they do? They formulated a 10-year project to support the Ministry of Justice, the Supreme Court, and the Public Prosecutor's Office carrying out reform measures. In recent years, the courts in New York evolved as well into a unified system to manage better, among other things, the volume of cases, physical infrastructure, and human resources. But is Nigeria ready for these sweeping reforms? My guest, with vast legal experience both locally and internationally, analyzes some of the issues. So, on a scale of 1 to 10, what would you say our judges in Nigeria rank in terms of global best practices?
I would say above average.
Why would you say that?
A lot of problems. The conditions on which they're working, congestion in the courts, this militates against efficiency, attitude of lawyers, I must say, and the general Nigerian factor. So all this hinders their ability to perform. If you correct some of this, then maybe you can say they'll be brilliant, but given all of this, I would just say above average.
What do you think the constitutional mandate of the judiciary is? When we look at their role or their position in as the third arm of government, the executive, the legislature, would you say they are the weaker link, or would you say the executive has more powers over the judiciary and the other arm of government?
Well, they're definitely the weaker link. They ought to be stronger than they are, because the judiciary should be constitutionally should be there as a check, not just on other arms of government, but also to determine the rights of ordinary citizens in the face of executive action or legislative action that impugns on the rights of the individual. By and large, they discharge these functions as well as they can.
How bad is it?
Well, it's not all doom and gloom. I mean, so let's get that one thing clear, and you have to commend the judiciary for what they're doing. But one, there isn't sufficient financial autonomy. Two, the conditions on which they work are atrocious. I mean, they still write in longhand. They're expected to hear 20, 30, sometimes 50 cases in one day. A lot of this affects intellectual input, aside from the burdens it has on their own physical and mental well-being. So when you take into account all those things, and then, of course, societal pressure.
The president talked about the special courts, special crimes courts that he's asked the judiciary to sort of structure. What benefits would you say are there to having the special crimes court, if any?
A special court would be of limited jurisdiction. And what you're going to have is lawyers challenging the jurisdiction of the courts. Given the congestion in the courts, given how long it takes for cases to be heard, you could be stuck in court for years on just preliminary issues without getting to the real, answering to the real charges in the case. That is number one. Number two, what does it do for public confidence? The fact that the government is interested in certain aspects, in certain institutions, and you then say create special courts for them. It's not good for public confidence in the administration of justice. Third, if the special courts are going to be of any value, you also got to give them special treatment, i.e. improve facilities, improve conditions for the courts and the judges to operate. So when you start giving a set of judges preferential treatment, again, what does that do for administration of justice?
When it comes to a matter of trust, the executive has fingered the judiciary in the past as bad eggs and perhaps doesn't trust them to entrench rule of law, for example. And perhaps that has affected that relationship.
Well, there are bad eggs in institutions, but you look at the institution as a whole. Okay, the institution can cleanse itself with time. Okay, but you got to let it function. You do not say because there are bad eggs, you then discredit an entire institution or stop an institution from working because of bad eggs. Then what then happens to the to the people who faithfully carrying out their duties and carrying out the oath that they've taken, which is justice according to law, without fear or favor? And that's the majority. So if you then, because of the bad eggs, you then make it difficult for the good eggs, so to speak, to function, then you are in fact actually doing more damage than what the bad eggs are doing.
How much reforms do our laws need? They've talked about some of our laws that perhaps might be obsolete. When we're talking about reforms, how much of that do we need as it stands?
The laws don't need much reforms. I think it's the application. You see, the one thing for orderliness of society, the one thing that must be certain is the law. The ordinary citizen is entitled to go to his lawyer and say, look, I'm in A, B, C, D, E situation. What are my rights, or where do I stand? And there really ought to be certainty. You get the odd cases where situations are difficult, you call those ones the hard cases. But in 99% of the cases, you ought to be able to say, if this matter goes to court, this is the most likely outcome.
Now, the president lauded the dedication of the judiciary, but he also said recently, quote, I am proud to observe that the judiciary, both before and after the elections, has improved in its ability to conclude election matters in a timely manner. He said there is still room for improvement, and is urging the Chief Justice to initiate a study to understand the challenges of adjudicating election matters and advise him, so that the executive can take steps in addressing those challenges.
Actually, it is not the judiciary that has improved in that sense, as regards the timing of the conclusion of electoral matters. It's the law that has changed. Prior to 2010, I think, election petitions will run for as long as they are concluded. In 2010, the Electoral Act then prescribed that they ought to be concluded within a particular period in the tribunal within 180 days, and then thereafter, I think 60 days and 60 days. So the courts adhere to that.
What's your take? Special courts for corruption cases, will that put an end to the hydra-headed monster called corruption?
Yes, like I said, I don't think we should create a special crimes court to fight corruption. We could let us have a criminal division of the High Court, and appeals from there go to the criminal division of the Court of Appeal. So all matters to do with crime, including corruption. And if you're talking of special courts, the people who really need special courts are the poor litigants who languish in jail for for months for petty crimes, who cannot post bail, and whose cases have to wait on and on. If we must create special courts, why don't we create special courts that will ensure that these cases get dealt with quickly and effectively?